The next matter coming before the court is Hartman v. As you know, each party will have 15 minutes to present oral argument. I'll let they reserve up to 5 minutes for rebuttal, and do let me know I'm keeping time.
Your Honor, if it pleases the court, Attorney Inman, on behalf of Mr. Hartman, I would like to go ahead and reserve 4 minutes for rebuttal.
Okay.
Your Honor, if it pleases the court, this case intersects the world of finance and law, and it comes down to a very basic question, and that is what is determined to be equity in a residence. Mr. and Mrs. Hartman had filed for divorce. I actually believe Mrs. Hartman was the plaintiff in the case. Come to an agreement back in June of 2013, in which Mrs. Hartman, as part of the negotiation, awarded the marital residence and the equity in the house. And I'm pointing specifically to page 3 of the divorce decree dated June 3rd, 2013. The problem came in is that in subsequent filings and remedies, the the mortgage company released to Mr. Hartman the escrow amount that was contained in his mortgage fee. So the funds that were reserved for taxes, insurance, things of that nature, PMI insurance, things like that. When that was released to Mr. Hartman, we came into the current litigation, which was the question of whether or not that escrow was to be considered part of the equity in the home. Problem with the trial court's decision, and it's multifaceted, and just so the court has a little bit more background on what was going on at the time. When the parties entered into their agreement in June 3rd, the divorce decree was finalized, the final hearing was conducted in the domestic relations court, and then approximately 2-3 weeks later, there was a subsequent proceeding that had been filed in juvenile court by Children's Services regarding the children themselves. So the children themselves were removed from the divorce litigation, and that jurisdiction over them had been transferred. There had been follow-up litigation with regards to questions of who was supposed to be responsible for paying the mortgage, who was to receive funds from dispersal. There was a number of items that would be sold, and so forth. What ended up happening was that the title to the house itself had not been immediately transferred upon the divorce decree, and it wasn't done springing. And the reason for that was because there was a question as to whether or not Mrs. Hartman was going to be able to refinance based upon her credit score and a number of other issues. The house ultimately did transfer to her and a gentleman by the name of John Ilg, who, neither here nor there, but the two of them entered into a relationship subsequent to this. When the escrow funds were released to Mr. Hartman, because it was not specifically included in the divorce decree as to what happened with that escrow account, that's when we got into the issues. There were a number of motions and cross motions filed, and what the court ended up coming up to the conclusion in paragraph 3 of its decision was that the husband was responsible for repaying the money that had been released from the escrow account. And what we're asking this court to do is to make a determination as to whether or not the escrow money itself would be considered to be part of the equity in the residence. And that's where I cited into, I think it was the HUD instructions, and then also into some other definitions that clearly demonstrate that escrow is not determined to be part of the equity. So for example, you could in theory have a house that was in negative equity, but the escrow account is completely separate from that. If a house has positive equity, which actually I believe this house is in positive equity, Mr. Hartman was not entitled to any of that equity that was solely per the divorce decree itself to be property of the appellee. problem is that when the court tries to lump all of these funds in as one big, under the one big definition of the term equity, I think that that's where we're having issues, because it's not considered to be part of it.
Use the term equity and just looked at the fact that White had, I guess, shortly before the court ruled, had paid an amount similar in size to the amount of the check. And the court looked at that and looked at the separation agreement, the fact that White was foregoing spousal support for equity in the home, and just had said nothing about equity, and just said this is the equitable thing to do, is to have White receive that money. Would we be here today?
I think so still, because we go back to what was the original divorce decree and the contract between the parties.
What's husband's claim to the funds?
Well, there were two issues. One is that wife had claimed that she had made sales on made payments on the mortgage itself. There was also a counterclaim, I think, was attached to the affidavit in the motion to show cause, or motion to show cause and motion to modify the decree that was filed on November 1st of 2013. That he had also made payments on the property since the divorce decree itself. And so there was a combination of the two that both of them were making payments on. The problem is that it goes back to the language of it, and it may have been that it was not a foreseen issue with regards to the language of the divorce decree, which specifically laid out that she was only entitled to the equity in the house. There were a whole bunch of trade-offs made in that divorce decree. It wasn't just the issue of the house, but there was retirement accounts, there was cars, there was other various properties and so forth that were to be divided up. And so it was a give and take. But what I'm saying is, if there had been, as traditionally you'll get it, or as traditionally I've seen at least, you'll get an order that specifically transfers the house immediately upon the divorce or upon some actions thereof, where there's a clear demarcation at approximately the time of the divorce decree, then I don't think we would have this issue. But in this case, excuse me, there was a number of months that had passed, and so the equity escrow account continued to build up, and then it was released upon the transfer by the, I believe it was by the mortgage company. So, yes, Judge Shaker.
In the divorce decree, I'm looking at, all it says about the marital home in the divorce decree is that she shall maintain possession of the marital home. She's going to refinance it within 1 year. If she's unable to do that, the property's going to be sold. It doesn't say who's going to be making the payments during the 1 year or however long it takes her to make.
Correct.
It doesn't say that.
Correct.
Where was it? Was that the temporary order hearing? Do we have a copy of that in the record? Where was somebody ordered to make the payments on the house?
Nobody was made, or I don't believe it was anywhere in the decree itself, or in the temporary orders hearing. I don't even have that.
How were the payments made then?
The payments were made by Mr. Hartman because the loan itself was in his name.
But there's nowhere in any of the documentation does it say who's going to be making those payments on that house.
Correct.
Anywhere.
Correct. I'm not arguing. And it was something that was not foreseen at the time.
Did somebody have to make payments on the house?
Well, the payments were made. There's testimony that both of them had made payments on the house itself. At the time, I believe there was a dispute as to the language in the decree that indicated that each one was responsible for their own debts.
But if the house is in his name, is that his debt?
Well, that's the way that it was partially interpreted.
But she's living in the house.
She was living in the house with the children, and it was a split relationship with regards to the children. So she had essentially taken over the house, and then the house later itself was refinanced and sold in both, or not sold, it was transferred into the name of Mrs. Hartman and a person by the name of John Hill. But the decree itself did not state specifically who was responsible for making the mortgage payments on the house on John's Road.
So the funds that were in escrow at the time the title transferred over to her, some of that money was tax money, which is payable in advance or payable in arrears.
Correct.
Okay, and some of it was insurance money.
Some of it would have been insurance.
Which is accumulated to pay future payments.
Correct.
So how is that accounting different than any other bank account, or even the miles on a credit card that are accumulated as you increase the balance on your credit card. How is that money any different than a bank account?
It's not. I mean, for all intents and purposes, I mean, what the purpose of an escrow account is essentially to serve as a bank account.
It accumulates funds.
It accumulates funds. But those funds then would be the property of Mr. Hartman because the loan itself was in his name that way.
That would be on the settlement statement when she, is that in the record as well?
No, the settlement statement, I don't believe is in the record at all. So, but those funds, because the loan would have been in his name, the escrow account was in his name at that point as well, or would have been in his name. Because the mortgage was purely, I believe it was contained somewhere within the record, but the mortgage itself was in his name, so then the escrow account would have been in his name as well, which is why the funds were released exclusively to him. They weren't released. I believe the check is in the record because it wasn't considered to be joint property. If the mortgage was since the mortgage was just in his name.
But once the house is transferred to her name, who's supposed to make the payments on it?
Once the house was transferred to her name, then it would have been reverted to her. The house was refinanced in her name and in the name of John Hill. And so that's when that escrow account at that point would have became her property. And then obviously the title company would have settled up with regards to taxes and things like that, insurance. Am I making sense, Judge Schaefer?
Yes.
Okay. Unless the court has any further questions. Thank you.
No, and you were right at 4 minutes.
I'm working on my time.
Good. All right.
Afternoon. May it please the court, my name is Rebecca Black, and I am the attorney representing Ms. Desserai Rennick, now known as Rennick, excuse me. Ms. Graham Hurd and I wrote the brief, and she has asked me to, with your permission, of course, represent her in the oral argument today. Okay. I think your honors have made some excellent points. Judge Moore, for instance, you were talking about this being whether or not this is an equitable decision that the judge was considering. And that is, of course, our viewpoint. Based on what is stated in the Chapter 31, Section 05.171F, that is the section on the factors for the division of property in a divorce, as well as what is in the next section, ORC 3105.18C, specifically 1I and 1N. These factors deal with the court's ability to make equitable decisions in the disbursement and division of property as well as spousal support. I think the point that wasn't addressed in Attorney Van Ho's argument was that the specific wording is any equity in the home, not the equity, as well as this equity being in exchange for spousal support. And I think that changes the nature of Your Honor's review of this case based on the standard of review being abuse of discretion.
Well, let's expand on that a little bit. The trial court's order says the court is not persuaded that the amount ordered to be paid to the plaintiff was equity or escrow monies. So that lends itself to a conclusion by the trial court that this is just equitable, that it goes to the plaintiff in this particular instance. However, skipping over a paragraph related to that issue, then the next paragraph said the court is restricted to the plain language of the decree regarding the equity from the marital residence. The magistrate was within his discretion to find an award of payment as he did. Is that the court's standard of review of the magistrate's decision when there are objections being filed, whether or not the magistrate abused his discretion?
I am, at this moment, not sure that it is, but it is also whether or not there is error, and they have the power to adopt, modify, and there is a third one, I believe it is affirm.
Sure, and then the next paragraph says, "The court finds no error of law or abuse of discretion." There was some prior discussion about other matters about error of law in the magistrate's decision, and therefore the defendant's objections, whether dealt with specifically or not, are hereby overruled. It kind of sounds like, from that language, the trial court itself is acting more as some sort of appellate review, and I'm not sure what we're supposed to do with that. It does make the necessary findings to make the order final,
Yes.
But I just wondered if you could speak to that language being in there, and whether or not the trial court applied the proper standard in dealing with the defense objection.
Really, what the trial court is required to do, it's my understanding, of course, is to make sure, I'm sorry, I'm thinking of the appellate standard. The trial court is, it is in a way looking at discretion. Unfortunately, what is in the magistrate's discretion, because they are the trier of fact, and they're looking at the facts as presented through the record, and as well as, maybe not as important when you're looking at arguments of counsel and proffered testimony, I believe. The credibility of the people offering that, I'm not quite sure that that applies in this situation, of course, but I'm afraid I'm a little unable to answer your question, perhaps.
Well, and that's okay, because it came from the bench, and it wasn't as if it was something that was argued. Okay, when we start talking about the fact that this is equitable outside of whether or not it was equity in the marital home, then I just wondered, does it raise the ire of that particular question? Does the counter argument that this is otherwise equitable raise this issue about what happened and then in the language of the order? And you have addressed it. Thank you.
Thank you. Are there other questions before I continue? Okay. Another point that we do need to bring up, Judge Schaefer, you had started talking about this. I believe that there are some drafting issues in this document, and that there is the maxim of the flaws in the contract should be construed against the drafter. It is my understanding, although again it's not necessarily in the record, that in this case it was Mr. Hartman's attorney that had drafted this document. And if it's not in the record, please by all means ignore my argument.
The separation agreement?
Yes. Maybe in the boilerplate in the last couple pages. That was attached to our brief at least.
All I have is the judgment decree of divorce, and it has a shared parenting plan attached, but the judgment.
Okay, then it is part of the decree, I apologize.
But I don't see any, okay, yeah, it's part of the decree. But
Mhm.
was that drafted by the court?
That is not my understanding. I believe it was Mr. Hartman's attorney.
Who drafted the judgment entry decree of divorce?
Yes, that is typical for that to be a proposed entry, is my understanding. If Your Honor, have no further questions, I believe that's the major points I wanted to bring up today.
Very well, thank you.
Thank you.
Ms. Vanho, you have 4 minutes remaining.
Unless the court has any questions. Thank you very much.
Thank you both for your presentations. advisement will issue an opinion which will be sent to both sides, and do check the Supreme Court website